separated from you, and he wishes you luck, and he won't beat up anyone that you talk to. Ultimately, the first several days of the senior trip seemed to go fairly well. There were some arguments, but nothing totally unexpected. Hindsight's 20/20, of course, Your Honor. The group were staying in a condo. They went out to parties at night, or the non-drinking parties that were common in Myrtle Beach, where risk and can't be served. Then on June 6th, 2023, they had not been acting as a couple. Matter of fact, the testimony of the kids were saying that we are broken up. Don't you know that we're broken up? And the text messages correspond to show that that was in the mindset of the defendant at the time. But Natalie was texting the young man that came down from the area also was not staying with him, a man named Caleb Lyons. Those text messages indicated trying to leave the beach. And at one point in time, one of the text messages, Caleb Lyons calls her Betty or baby. That's important because later on, when Mr. Linkous is talking to the police department, says he called her Betty. I don't know what's going on. Finally, the night in question on June 6th, the group had tried to go to the House of Blues, what was going to call a phone party, which is folks that are underage and get in the House of Blues and hang out.
Is it a phone party?
It's called a phone party, which basically I found out, I didn't know it was just
like phone? Like
phone, like spray foam inside there. Apparently it's flashing lights and foam and things like that. They're all underage, so they were denied entrance. So one of the individuals had a beer in his hand, was underage drinking, tried to set it down and get in there. The folks saw it and wouldn't let him in there, said, you got to go, you're not going in, you're drinking. They were told he had to go back to the condo. They got Ubers, and so Dakota Hall, Blake Linkous, and Natalie Martin left the House of Blues to go back to their house, or to go back to the condominium they were staying in. They got back there roughly 9:46 or so. There was some phone activity. We exploited the cell phones pretty well. There's some user operation with Mr. Linkous with the Uber. They're contemplating going back. But at the same time that was happening, Natalie Martin was looking at her phone and texted Caleb Lyons, who's at the House of Blues, and had asked Natalie to come back to the House of Blues, come back where you were. And I think Natalie's second to last text message, she told Caleb Lyons that she would try to come back. She accessed the Uber app to get a ride from there. You see the Uber download information where she did the code sent back to the Uber app to get a ride. And there's some evidence indicating Mr. Linkous was trying to go back to the House of Blues too by him accessing the Uber app. Her last text message was to Caleb Lyons at 10:11 saying, are you in line? Caleb Lyons expressing her intent to get out of the condominium. As it interests both of their phones, their activity ceases at 10:17, and there's no more phone activity on that one's phone forever. At 10:17 to 11:02, there's no messages on Blake Linkous' phone. At 11:02, Blake Linkous texts his parents, actually his dad. He texts his dad, quote, I got mad and screwed up. I love you guys forever. I really don't want to do this, but I have to. That's the last subsequent text message from Blake Linkous. So it's 11:02 p.m. on June 6th of 2023. The other individuals come home from the House of Blues are unaware because the door's locked, unaware of anything's going on. It's only until the next morning that they become aware of the problem when the defendant comes out of the bedroom and says, I think I did something. I may have showed Natalie last night. Different versions of the same thing. And he had a hesitation marks on his wrist as well as he had a small cut on his chest. During the course of his post-traumatic statements, law enforcement indicated that he didn't want to live without her and decided that he was going to try to take his own life. They were very superficial. I think they was transported, put a Band-Aid on his chest, and the hesitation marks didn't really require any treatment. But they do manifest, as you're well aware, evidence of suicide is we can use that to prove criminal intent. That's certainly one of the things that we would do if this case had gone to trial. Upon that disclosure, and at 10 o'clock the next morning, the friend friends, Natalie's friends, tried to go and help her, and they found her on the floor of the bedroom back. I showed this to the defense counsel already. Put this on the screen. That's the scene that they found when they came into the bedroom. Of interest, she's wearing the same clothes she wore in the House of Blues. That's kind of outfits and stuff. By that time, EMS, when they arrived, obviously 911 calls go out of some interest, and Mr. Linkous didn't call 911. The kids called 911 to try to help her. She was very obviously in a condition that was beyond help at that time. The forensic indicators that she had passed on hours prior. Of other interest, law enforcement interviewed Mr. Linkous as he had been transported to the hospital because of the suicide attempt. He gives about an hour and 4-minute statement. Through that hour and 4-minute statement, he initially says, I don't recall anything, I can't remember what happened. I must have done something because no one else was around to have done something. I kind of engaged in a little bit of progressive truth telling. I don't know anything and start to know something. But the first statement is not terribly compelling. He was brainwashed twice in the first statement. The second statement is in the Anna Brown building, post-Miranda statement, where it's much more forthright. In that second statement, he talks about putting his hand on her neck, 1 and 2, strangling her until she fell off the bed. And then going over wound sleep about her remediating time. He also acknowledges that she was texting another dude, and she called him Daddy. And I don't know why now he's not even into him that much. I don't know why he would do that. That's the relevance of prior text messages when the only basis is a controlling unrealistic jealousy, when it made it pretty clear to Natalie through her text messages that she was prepared to have this thing over. So I don't know. That's the basic fact we present. We had a lot of other aggravation, I guess, from the family speak. So I don't want to.
I just want the basic facts of what's alleged to have taken place so that he can agree or disagree.
Yeah.
Sir, do you agree or disagree with the facts?
Yes, ma'am.
Agree or disagree?
Agree.
Feel anything needs to be changed or added to the facts?
No.
Are you pleading guilty, sir, because you're guilty?
Yes, ma'am.
Do you understand you're entitled to a jury trial?
Yes, ma'am.
Do you understand that we have a panel ready and still ready, that the court can qualify and select a jury if it is your desire to go forward with a jury trial?
Yes, ma'am.
And knowing all of that, do you wish to waive your right to a jury trial?
No, ma'am.
Do you understand the question? Do you want a jury trial or do you not want a jury
I
trial?
do not want to hear you.
Okay, so do you waive your right to a jury trial?
Yes, ma'am.
Are there any deals the court has not been told about?
No, ma'am.
Have you been satisfied with your attorney?
Yes, ma'am.
Has he done everything you've asked or expected?
Yes, ma'am.
Any complaints about his services?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone threatened or forced you?
No, ma'am.
Are you pleading guilty freely and voluntarily and of your own will?
Yes, ma'am.
Have you understood my questions?
Yes, ma'am.
Do you need to ask any questions?
No, ma'am.
Have you been truthful?
Yes, ma'am.
Do you understand that you have the right to appeal this guilty plea and sentence?
Yes, ma'am.
Do you understand you have to do that in writing within 10 days of today?
Yes, ma'am.
Do you understand that if you cannot afford an attorney for that process, that one will be appointed to you at no cost?
Yes, ma'am.
I find there's a substantial factual basis for the plea that the defendant has entered the plea freely, voluntarily, knowingly, and intelligently, with the advice and assistance of counsel that he's indicated to the court is satisfied, and the court qualifies the plea. Anything further from the state?
Yes, Your Honor. So it specifically relates to, I guess, what's called aggravation. And the reason I say that is because this is a odd situation where we're dealing with a no record that's a 30-year. The South Carolina State Legislature has in their discretion given Your Honor by discretion to matter from 30 years to life in prison without the possibility of parole. And we just ask to be heard just a little on that. Procedurally, Mr. Linkous was granted bond after this thing came back and has been out of jail on the electronic bond ever since this happened. We had an arraignment hearing at the time, a lot of conversations with the family.
So what was the date of arrest when you say since that time?
Yes, so his date of arrest was, I think the warrants were signed 2 days later, so it was June 8th, 2022.
And then when did he have his initial bond hearing?
His initial bond hearing was June 29th.
So he
Because
waived
of
the one,
self-inflicted.
he waived the one where the magistrate could not say.
Yeah, we have here, we just have a basic appearance and then,
Yeah, which is the normal way. So then he had a bond hearing in the circuit court on June 29th of 2023.
that's correct.
And what happened at that bond hearing?
Judge Tommy Cooper set a $50,000 bond on him with some conditions, including electronic monitoring, and to have a health assessment or a mental health assessment because of suicide attempts, custody of the parents.
I seen strict house arrest since it was GPS.
It was not house arrest, it was electronic monitoring, but it was not, Judge Cooper did not house arrest him because he was leaving South Carolina because that's what he finished to go back to Ohio.
So he allowed him to go back to Ohio.
Yes, ma'am. Yes, Your Honor. So procedurally speaking, I guess initially, I think Your Honor asked this earlier, but initially we had an arraignment on him in August. We were going to try to get this thing to trial or get it resolved in August. I think at that time we did.
August of 2023? Or what year?
August of 2024.
Okay.
Yes. And we brought the family down. It was our understanding that Mr. Linkous may have pled guilty at that time. And at that time they offered him half 40 years to argue down, or if you wanted a specific number, we offered 35 years negotiated sentence. At that time, the defendant declined to accept that offer, and then we had went to set this trial, of murder trials as soon as possible we can. We looked up with the parties to try to figure out when we could do that, and March 3rd was the most appropriate time we could get this scheduled to trial. I just say that as it relates to the acceptance of responsibility. Obviously, it goes without saying the fact that the criminal defendant standing before the court and asks for mercy. Not lost on any of the parties here, but a step in the right direction, that is to accept responsibility, but not a lot of assurances. And we certainly understand that that's appropriate. But it's also important that the court sentence him based on the individual facts and circumstances of the individual case, given the fact that he has accepted responsibility. It has been a difficult time for this family. I'll speak for them for a second, given the fact that Mr. Linkous was out on bond. He had been out in the community for this entire time. Very difficult for them to understand how someone could admit to putting hands on their daughter or family and killing them, and he's around the community. It's been a very difficult experience for them, to say the least. And then for them to come down in August and think this thing was behind them and not accept responsibility then to go in. So when I talked to them about the fact that accepting responsibility is an important part, they're slightly incredulous about really accepting responsibility. They kind of been here before and that didn't really happen. So I guess
it would be unusual, you would agree, that somebody would plead at an arraignment.
100%.
I think it could prove problematic for his lawyer to do it that quickly.
Absolutely.
Without having, without me going into minutia, I think
Absolutely.
that would be problematic. So what changed from the cap of 40 years to the negotiated plea of 30 years? And I guess maybe nothing has changed because I haven't heard what you're requesting before.
No, so it was a cap of 40 or a negotiated 35. One of the biggest problems I know I hear from Jesse Martin is the victim's father, who's been through a lot through this process and would like to address the court at the appropriate time. There's always a difficult time with this case because of the extraordinary violation of trust that were going on here. We never thought that the mandatory minimum sentence was appropriate. And what we foresaw happening in the trial of this case was a joint of the issues of whether voluntary and manslaughter would come in, whether or not there would be of import for Your Honor to be aware of. I think during the course of these almost 2 hours of statements, about 14 to 15 times, Mr. Linkous was directly asked, did she do anything? Did she hit you? Were you arguing? What was going on? And that directly on 15 times, he said no. I anticipate if there's litigation issues and stuff that I'm not privy to, with those litigations, I think it was manifested through counsel's pretrial brief, which indicated that there was an allegation of assaultive behavior running up to the killing that may give a chance of mitigating it or not, mitigating not voluntary manslaughter. Obviously, I'm not privy to the decision-making process and how strong that would have been, but I do believe that would have been an aggressive trial. For the state's purpose, the big concern we've always had was our forensic pathology, and the reason I so difficult is these families ate dinner together in the same room. They know each other quite well. They were high school sweethearts. They helped each other through this process. It is a breathtaking violation of trust when you believe. In the interview, Mr. Linkous is talking about, well, what will Mr. Martin say? Does he know what happened? Does he know yet? It's a very difficult thing. That's why there's so much interest about it. It's a very difficult process. The other problem that we've had a very difficult getting around is the mechanism of injury. When in preparation for trial, I talked to Ellen Reeder, who's our forensic pathologist, and testified to it. And she said, when I brought up, I need you to testify about the autopsy in this matter, the first thing she told me was, oh, I remember that. She said, the amount of trauma of that young woman's diaphragm around the throat area of the tongue, the neck, it was substantial, the hemorrhage inside that. And she would testify to that, and now is not necessarily the time to lay a forensic pathologist's testimony out in front of the court.
Well, I think based on the breadth of this court's experience, that manual strangulation takes an inordinate amount of force, and I don't think I need the forensic pathologist, although I have a great deal of respect for Dr. Garner. She's from MUSC. I hear her testimony along with the other forensic pathologists a lot. It could prove corroborative, but I really don't. I think I can imagine how violent manual strangulation is and the amount of force it would take to accomplish that.
Her full quote, the best that I can summarize it for the court for the purpose of sentencing proceedings, is she said, I remember this. She said, Scott, that's a very, very intentional act with a substantial amount of force over a prolonged period of time. And I said, I get it. And so from there, it's not that we're mitigating the use of a firearm in a case where a round goes off and someone's struck with an instant analysis of forethought, Your Honor, but the fatal blow is struck kind of quickly. Even by the defendant's own statement, at any time, if he decides to let off, Natalie's here. Maybe he's charged with domestic violence, although he could be because they're not cohabitating domestic partners, but they're in a love interest. But we see it all over and over again with domestic violence abuse, harassment abuse, stay away from me, leave me alone, and then we see the death of someone at the hands of a paramour. It's just a tragedy to see at 18 years of age. True tragedy. That's why we've always had when I speak for the family, we say we, it's not about me, it's about these people, this family. Why a mandatory minimum doesn't do justice, even though we fully accept and appreciate the acceptance of responsibility and what it would feel like to resiliate all of this of people that we love and we've had dinner together and stuff like that. And so it's not lost on the acceptance of responsibility is clearly important. I know that Mr. Martin would like to speak at the appropriate time. I know that Natalie Martin was 18 years old at the time, and it just seems poetic justice to some degree that for every 18 years of her life, we double it up. At least 36, if not more. So,
yeah, that's, excuse me, I apologize. That would be because you talked and you've been very specific in terms of explaining the nature of these circumstances to the court, but you haven't put a number on it, and I need to know what you're requesting of the court.
Well, we were absolutely happy with the cap of 40 years, to stand and ask for 40 years when we made the offer before. We certainly understand that usually I don't offer 40 again because you refused it when you had it on the table, and so it's going up from there. So I don't want to outtake my coverage and be rude to the court, but from the government's perspective, you had 40, didn't take it. The cost of the state had increased, the sleepless nights to this family's increased. Other trials have gotten bumped this week to go to trial, so the cost of the state increased beyond that as a basic criminal justice principle that we embrace. So
are you requesting 40 years, or are you saying something?
45 years.
Okay. Is there anything else you'd like to present to the court regarding the sentence?
I do, but I want the family to do it because I'm a lawyer that gets paid to talk, and so I'd love for the family to. That's perfect.
Sir, if you would tell us your name for the record.
Good afternoon, Your
Good
Honor.
afternoon.
My name is Justin Martin. I'm a
said Jesse.
Jesse, yes
If
ma'am.
you could spell that for the court.
Jesse.
And you, sir, you may proceed.
June 7th, 2023. We get a call, but we don't know where Nat is at. Nobody knows what's happened to her. We can't get a hold of her. We can't get a hold of any of her friends. So we do what any parent would do. We jump in the car and head to South Carolina. Exit 25, Your Honor, is just a small right here off Interstate 77. And, we're rolling down through there, trying to, hear from anybody who's calling, who's saying anything. And then right there, exit 25 is where Conway, South Carolina, comes up on Natalie's mother's way. So immediately, I'm feeling a little bit of relief, like, did she get arrested? Did they find her? Is she okay? Well, at exit 25, Your Honor, that's where we pull over alongside the interstate there. And that's where the gentleman, I don't recall his title, but he was with the Horry County Coroner's Office. He made us aware that he had Natalie, and she was gone for manual strangulation. So, that's where we get out of the car and we land on the side of the road. We flop around. We realize we're not going to see our little girl again. Right there alongside the road. That's that. Then we go home, a week or two later. The judge slammed the gavel and he says, for the price of a used SUV, your daughter's murder can go home for the next 635 days. 635 days, he's been living his life, running around, doing whatever he wants to do. I'm not here to argue about the policies and procedures and all proceedings in the state of South Carolina. I know that I'm in over my head over that. But, the reason he was granted bond by Judge Cooper is because he wasn't violent. I think my daughter would beg to differ of whether he was violent. 635 days. That's 2 Father's Days. That's 2 Thanksgivings. That's 2 Christmases. It's an Easter. And particularly a painful Mother's Day. 635 days of every day, me waking up and deciding whether is this the day that I don't care about the judicial system? Is this the day that I don't care about consequences anymore? Because it doesn't feel like anybody else does. 635 days of that is impacting the daughter. It's impacting on your own mental health, your own state of mind, trying to go to work every day, trying to live your life, trying to be happy about simple things, while your daughter's murderer is eating his mother's food at home, laying his head on his pillow. And it's like, try to mitigate, try to cross out the negative with the positive, if you will. And, in my mind, I got a slideshow, if you will, that I play of just time with my daughter. Thoughts, positive moments with my daughter. And I say slideshow because it's like, it flashes in front of your eyes, You got this moment, and that moment, and that moment. And no matter what, the beginning or the end of that slideshow, Your Honor, is when I last saw her. That was in her coffin. She looked beautiful as always, but she looked
sad, and her lips were a little bit blue. And the reason that she was sad looking and her lips were blue, because she was dead. Because Blake Linkous wrapped his greasy, cowardly hands around her neck and he strangled the life out of her. And then somebody, after that, at the state of South Carolina said, let's let this guy go home. Again, for the price of a used SUV. Let's let him go home. We'll wait 635 days. Thank goodness we're here today. And maybe then we'll give him a punishment. And I guess, Your Honor, to take it back to exit 25, why that plays such a significant role in my life. Everybody here is going to drive back past exit 25. I drive by exit 25 for my work 3 or 4 times a month. And I can, up until this day, all I can say is when I drive by exit 25 and I recall me and her mother laying in the gravel in the ditch, bawling our eyes out, asking God why. All I can say is the guy that done is still running around. That's all I've been able to say to myself up until today. So I'm asking you, I'm 44 years old, Your Honor. Am I going to drive by exit 25 when I retire? Is that going to be my retirement present to, know that Blake Linkous has a release date coming? Is it, am I going to drive by when I'm gray and bent and old? Am I going to drive by exit 25 and know that there's actually a date that I might be alive? And correlate that with it, if that makes sense what I'm saying, Your
Yes, sir.
I think what's happened is happened. There's nothing that you're going to do or say here today that's going to make me feel any better. You're going to let me smell his hair burn? That's what I want. That's what will make me happy. But we're not here about making me happy. You ask this gentleman what he recommends. I don't want you to ask him what he recommends. I want you owe the people of South Carolina, you owe the citizens and taxpayers of Horry County, you owe them, the knowledge to know that the judicial system has their back. Because right now, from where I'm standing, it hasn't felt that way. You need to be setting an example, sending a message to criminals, to law-abiding citizens and criminals alike, that we're going to do what's right. In 635 days of my daughter's murder out running around in Ohio, I don't know what the people of Horry County think, but that doesn't matter. That doesn't add up, Your Honor. So I'm asking you, to 40 years, 35 years, none of that means anything to me. I want you to sentence somebody that wraps their hands around an innocent woman's neck and strangles them to death. I want you to sentence them how you see it according to them. That's all I have.
Thank you, sir.
May the court close just for a second. Now, this is Brooklyn Farrell. This is still Natalie Martin's best friend. She was trying to come down and see her children, but couldn't. So good with that. She's not here. Thanks very much. I had to run over the telephone. She's been kind of asked by the other folks that were there kind of to speak on behalf of all the her friends outside of her.
I need to make sure that there is no exception to her speaking on behalf of the victim in this case.
You do not.
You may proceed. Tell us your name for the record.
Brooklyn Farrell.
And you can spell your last name for the benefit of the full report.
It's Ferrell.
Thank you. You may proceed.
Dear Natalie, today is Monday, March 3rd, 2025. It has been 635 days since I've heard your voice. I am currently sitting in a courtroom begging for your justice. The weather today has a bitterness of cold still lingering from the second winter season without you. Soon I will be hunting turkeys with your dad and planting flowers on on your grave with your mom, which are all things you love to do. Your mom has become my best friend. I see you in her every day. From her laugh to her strength, she reminds me of you. I often wonder what could have been, you and I. But you see, my fate is up to me, but your fate was up to a set of hands wrapped around your neck. Our 12-year friendship was stripped away by the bare hands of someone else 635 days ago. On June 6, 2023, not only your life was taken, but most of mine was too. That day will forever be embedded into my brain. I vividly remember crying so hard and so long that my eyes were practically swollen shut. Knowing that I would never get back even a breath of time that I shared with you destroyed my will to live. I had fallen so far into the darkness, I had forgotten what it was like to be immensely full of true happiness. But remembering who you were as a person has helped me to wake up every day and make something of myself. You were inspiring, caring, goofy, outgoing, but more importantly, you were my best friend. You were the one to be there for me and walk alongside me through every footstep of life. I believe that is what I miss about you most, your presence. How on any day I could look over in the seat beside me and see your piercing blue eyes and breathtaking blonde hair, looking back at me and sharing a heartfelt laugh. I would do anything to hear your laugh one last time. Now the only thing that I have left of you is our memories of this necklace I wear, which holds the ashes of your once full of life body. No goodbye text, goodbye call, or goodbye love. It's crazy how much my life has changed without you here. The loneliness that creeps beside me, echoing in a distance every day. How we went from talking and joking about making our own TV show to now my phone lighting up from messages of news broadcasters wanting to make a documentary of your murder. I truly believe that these feelings will never fully go away. But today, after 635 days, is finally the day that our family, our friends, and our community have prayed for. Today is the day justice will be served. Justice. Justice for you, your life, and everything you never got the chance to become. We love you. Throughout school, something Natalie and I did was write each other letters and pass them off to one another in the hallways. I still have every letter Natalie ever gave me. As I sat in an empty hotel room last night, tears flooding from my face, I timed approximately how long it would take me to read this to you today. In total, it took me about 3.5 minutes. In the 3.5 minutes it took me to read this to you, Your Honor, I wanted you to live, breathe, and feel just what 3.5 minutes in my life is like. The sniffles of noses that you hear, the tears that fall not only from my eyes, but from all of Natalie's supporters here today, and just the feeling of true, antagonizing pain and desperation. This is and has become who I am as a person. 3.5 minutes, around the same amount of time it took the defendant to manually strangle my best friend. 3.5 minutes, he had to change his mind just just for a second and allow my best friend to live. 3.5 minutes. The amount of time Natalie had to sit there and hopelessly fight for her life. Natalie does not get another chance at life. So today, Your Honor, I am desperately asking that you do not give her murderer another chance at life by sentencing him to life in prison without the possibility of parole. Thank you.
Of course, it goes just for one. That's all I got, Your Honor.
You're welcome. Ms. Humphries?
Please report.
Yes, sir.
From the first moment that I had an opportunity to sit across the desk from Blake Linkous, he told me, and this is a direct quote, that he had killed his best friend and he would accept any punishment anybody decided was appropriate for him. That's the way our relationship started. I've been doing this a long time. I was not convinced, even after having received the discovery and the recorded statements of my client to law enforcement, that the whole story had been told. I knew that at least on my client's part, that time had been fueled by alcohol. I knew that it was fueled by jealousy. I knew that it was fueled by confusion on his part. But I suspected something other than a text that came in that prompted him to act in the way that he did. And make no mistake about this, from the very beginning, there's been, I mentioned in my pretrial brief, this is an admitted guilt case, it always has been. But as his attorney, quite frankly, with little help from my client, I was not convinced that all of the facts were available to me in order to counsel him about what the best course of action would be. And quite frankly, I pressured him time and time again. If there's something else that needs to be fairly considered about your case, I need to know about it because I've got to advise you about it. We were scheduled for an arraignment, and leading up to that arraignment, quite frankly, the intention was, and has been, for my client to enter a plea at that time to murder, because quite frankly, nothing in the facts provided any argument for any sufficient legal provocation in connection with the case. His parents pressured him. We were very clear. We had no desire for him to manufacture some information in order to better his position. But if there was something we needed to consider, or I needed to consider, and counsel him on, I needed to know it then. That's when he advised me of something I believe, had it been credible to a jury, certainly if it had been credible to the court, it would have resulted in at least a jury charge for voluntary manslaughter. And the potential was there that a jury could return that verdict. Now, in fairness to the state, I advised them of that representation at that time. So this is not something that has come on the eve of this scheduled trial. They've known it for some time. Based on that, we declined the offer, and quite frankly, we pled that day, we declined the offer of negotiated 35 or a cap of 40. And we began to prepare for trial. I knew from that moment, literally until this weekend, that my client was reticent to go to trial. In fact, I think he felt as though he had to, based on members of his family's position who want the best for him. We met Saturday. I discussed at length, in great detail, the logistics of a trial, what it would look like, what it would mean to his family, what it would mean to Natalie's family. And after about 3 hours together, he looked at me and he said, "I don't want to do this." Do what? I don't want to go to trial. I've never wanted to go to trial. I was aware of his reluctance, but at that point, it became clear to me that any decision other than pleading guilty as charged would not be his decision. It would be a combination of others' decisions for him. We talked at great length about what that means. He's maintained that position, quite frankly, from the very day I met him. He's been of that opinion. And he explains that to me in this way. He killed his best friend. There is no excuse for that. There's nothing he can do to remedy that, to restore that. The only thing he can do, and the only thing he's been prepared to do since the very beginning, was to take responsibility for it and accept the punishment of the court. He is now 20 years old. Your Honor asked him if he had been working. He is not. Quite frankly, that's been on my advice. His GPS monitoring has, as a practical matter, been house arrest for that period of time. He's been in the company of his parents anytime he has not been in that home. He has no prior record. He has no prior record in family court. He was an 18-year-old boy. And he stands before you now, 20 years old, making what I can only characterize as a mature, considered, moral decision to plead guilty and accept responsibility. There is a range in this case. It's there for a reason. And Your Honor knows, and you've been on the bench a long time. There is nothing, and I don't want anything that I have said today on behalf of my client to in any way try and reflect negatively on the victim in this case, or the family. But it is an absolute certainty that what happens here today in this courtroom is not restoration. It's not restoration of anything. The courtroom is sadly inadequate to do that. Frankly, you can't do it in a grand larceny case. You certainly can't do it in a murder case. And the sentence that this court imposes today is in no way, under no circumstances, does it speak to the value and loss of Natalie Martin's life. That is not what this sentence says. Nor is it intended to. It's to punish this individual with his individual character, his life experience, his age, in the context of this horrific crime. It's to punish him, and it's to send a message, as all sentences do, to this community. That's what we're trying to achieve here today. This is a day-for-day sentence. There is no parole. There is no 85%. There's a reason why this legislature, in the case of murder, has given you a range of 30 years to natural life. There is that case. Under that sentencing structure, it calls for a 30-year sentence. I believe, under the facts and circumstances, that this defendant, in this context, at his age, his lack of prior criminal history, the influence of alcohol, that is an appropriate sentence. I have a number of letters in support. If I can approach the court, I've given them to the state that I'm not going to read them. The first letter is from his father. I do need to recognize that his father, his mother, and his sister are present. I've talked with them about addressing the court. They're certainly here in support of their son. They love their son. But they do not believe that they can make an oral statement in a way that they can communicate with the court. The father has provided a written statement, as well as many others. I'll give your Honor an opportunity to read those.
Do you want these made part of the record, or are you giving these to me just for my benefit?
For your, yes.
Are these your only copies?
Those are, I know, ma'am, they are not, and I have no problem with them making them part of the record. If you need to hand it to the clerk, I'll be glad to.
It's up to you. I just didn't know if you wanted to have.
That's fine, if they can be that appropriate, I think.
I'll read them.
Thank you. So other than from Blake Linkous himself, there'll be no others that speak on the record in his behalf. It's, I can tell you this. I have, without question, seen genuine remorse, genuine anguish, both from Blake and his family. And they love Natalie as well. Personally, I cannot imagine. I can't imagine that loss. It is my daughter's birthday. I cannot imagine.
The first letter, who was that from? That's not.
That's the father.
No.
Is that handwritten?
Who's William? I have that one that's signed by him, but there's one.
I think they actually put their name in the body of the letter. If not, I'll identify it for you.
Yeah, I don't have a name on it.
I'll let
You want to look at it right quick? It's attached to his father's, but I don't think that's.
Is this your old letters? All of you? This one is his. So the first is the mother.
That's okay. Just, do you want to write her name on it?
Sorry.
It's okay.
But that is the father's.
No worries. Is your client ever had any sort of mental health evaluation?
No, no, no. Well, fair, prior to his release, there was a threat assessment regarding suicide that was conducted at the detention center, and it was found that he was not an active threat to harm himself. That would be the only one of which I'm aware.
He's never had an evaluation to determine if he had some underlying challenge that was.
I believe he's been diagnosed with, he's on the spectrum. So I refer to that as an educational assessment. Yes, ma'am.
Does he take any medication for that?
No, ma'am.
Get any therapy?
No, ma'am.
But he doesn't have to have an IEP as a result of being on the spectrum, or does he?
There's no line. No. No, ma'am. as recently as the arrest. I'm sorry,
That's okay. What type of therapy has he been in since the arrest?
it's mental health therapy, counseling to deal with, quite frankly, with what he's done.
Anything further?
I know that Blake would like to address the court.
Certainly. You go ahead.
I was never trying to run away from this tragedy. She was the love of my life. I swore to protect her and I failed. I chose no trial to end some pain for Natalie's family and everyone else. That's it, Your Honor.
Anything further, Mr. Marcus?
Except to say this, I'm aware that in many of those letters of support there were requests for mercy. I was fully confident that you would never hear one of those from Blake Linkous. That is a request for mercy.
Anything further, Mr.
There you go.
The court's going to take a 3 to 5 minute recess after which we'll go in and sign.
Thank you.
You're welcome. appreciate your indulgence. I've learned through years of experience that some things, well, most things, when they require thought, that it's prudent to take the time to reflect and to do that. So again, I appreciate your indulgence in allowing the court to take some time to reflect on the facts and circumstances of this case. Without going into a great deal of minutia, prior to the solicitor indicating or making reference to Dr. Reimer's report, and just in preparation for this case, I already knew that it took a great amount of force to resolve it. It's nothing like, I think sometimes when people think about the facts and circumstances of criminal cases, they reflect on what they see on television, and I think we all know that what we see in real life is far more gruesome than that. And I already knew that for someone's life to end as a result of manual strangulation, just the amount of force that would be required was just gruesome. I don't know any other way, or any way to sort of say it. However, the court has weighed many factors, one of which is the particularly aggravated circumstance of what took place and what happened to Ms. Martin. The court also has to balance in that equation the defendant's youth, his inexperience, his lack of record, the fact that he was on the spectrum, which we all know affects the ability to report one's behavior in terms of anger, explosive type anger, actually, as well as certain boundaries. And then when you compound that with the use of alcohol that admittedly was present during this incident, and then also compounding that with age and inexperience, the court needs to weigh all of that. And I think a 30-year sentence under these circumstances, and while the court understands that as a result of this incident, not only was Ms. Martin's life lost, but in essence, Mr. Linkous' life, for all intents and purposes, was lost as well as just the sheer agony of the victim's family, and now the aftermath that Mr. Linkous' family must also face in light of the fact that their child took the life of someone that they knew, and probably considered as well a part of their family based on the letters that were presented to the court. And under those circumstances, the minimum certainly would not be appropriate. However, I do think that the state has requested is more than appropriate under the circumstances. And sir, you'll be sentenced to the State Department of Corrections for a period of 45 years. You'll get credit pursuant to 1340, which will be calculated by the Department of Corrections. Thank you very much. You're welcome. They said they were going to give me a docket for tomorrow, and when that's completed, if y'all just let me know, I'll probably be back in chambers for all our work.
Thank you.
Thank you all very much. Have a good day. Do you